but we have to criminalize and put them into lockup. This is happening. The very people who come and complain about their land being stolen are the very people who are selling the land. Selling the land. We conducted some hearings recently and we heard some stories and some accounts. And the public outcry about people selling land and we have been taken away and pushed away from our land. But hey, who's selling? The buying will stop when the selling stops. Thank you, Honourable Speaker, for the opportunity to add my debate to this most quite important, these various amendments in the land sector. Before I do, if I could also acknowledge the presence of the students from the Edevu Adventist Primary School in Hirikwayari District. So I welcome them and thank you for sitting through this very important hearing this morning. The same token, I welcome to the floor the member for Central Bougainville, Honourable Mering Toro, to serve his people on matters concerning this nation. I also stand here, Mr. Speaker, to support these amendments to primarily to the Land Act 1996 and various provisions therein. And I adopt the sentiments, the commentary shared by the debaters before myself, Honourable Sir Pukatemu, and the good Governor for Oro, Honourable Gary Jufa. But I'd like to add some thoughts, and it's my contribution to these amendments. For the record, on the hand side, and the good Minister for Lands and Deputy Prime Minister could kindly take on some of these views. And whilst I support these amendments, Mr. Speaker, I want to make commentary in relation to about 4 or 5 matters that are glaringly of some concern to a certain degree. First, Mr. Speaker, is in relation to the definition of customary landowners. Under the interpretation provision, Section 2 of the Primary Act, it says customary landowners, according to the amendments, will be included the following: means a clan, a lineage, family, extended family, or other group of persons who hold or are recognized under custom as holding rights and interests in customary land, and includes as land group incorporated under the Land Groups Incorporation Act, Chapter 147. Mr. Speaker, this is a serious concern. It has been tested and proven that the ILG Act has been a failure in this country. It is the cause for a lot of litigation in the courts, and this is how it works. In a nutshell, the ILG Act can be formed by, under the ILG Act can be formed by any manner of people in this country. Not necessarily genealogically connected by biology or otherwise, or even related to any spatial land geography at all. There is a great risk of how this ILG Act has been implemented in this country since its inception. The ILG Act, the background of the ILG Act, we must understand, was brought forth by the colonial administration to put into groups in their language, Kanakas, or Plesman, who were not identified or seen through the eyes of the law as legal entities, and that is the clans. And so that was proposed under the White Australian policy at the time. I say this unreservedly, by the colonial administration pre-independence, to give it prominence and to give it cognizance under the post-independence legislation within the process of post-independence decolonization. It's a fallacy and it's a high risk. It's very dangerous. Because we also know that there are ILGs in the courts on top of ILGs, and the ILG inventory suggests spaces of land that don't even belong to people who claim to own these lands. The definition now, a dangerous one, gives those rogue elements, the legal right to have claim over land.
Correct.
Well, no been owning Slaul ground. We have people who have only sit here 50 years and now claim ownership in areas outside the Hill Quarry. People from other districts in Papua New Guinea. Even within Central Province, we have this problem. Inter-district and outside of the district into other provinces, coming into Central Province. Hill Quarry, for instance. Same is true in Morobe Province and every other province, I'm sure. Same is true in Western Highlands Province. Everywhere in this country, there are people moving around because of one reason or another, maybe because of marriage. But 20 years living there does not entitle you or anybody in this country a genealogical connection to the land that you sit on or you squat on.
Correct.
There cannot be disallowance. We have to be very careful and respectful of our people and our indigenous respective lines of genealogy. And number one thing, Number two, the area Mila contributes, Mr. Speaker, is positive and also a negative, and that is Section 132 of the proposed amendment deals with a declaration that any purported disposal of land is criminal. And I commend the good minister for this pronunciation again, only to the extent that it does. But my reservation and my concern, or rather suggestion, would be that we add a penalty prescribed to the criminalization of sale of customary land. It's fine and very well to say that it is wrong and it's criminal to sell and buy land that is customarily in nature and undocumented or not state land. That's good. But then you have to, by law and good practice, prescribe a penalty. Man must carry him heavy. You don't just tell them it's wrong, but we have to criminalize and put them into lockup. This is happening. The very people who come and complain about their land being stolen are the very people who are selling the land. Very people who are selling the land. We conducted some hearings recently and we heard some stories and some accounts and the public outcry about people selling land and we have been taken away and pushed away from our land. But hey, who's selling? The buying will stop when the selling stops. So we need to just put that extra part in. If there is a way to bring this additional prescription, Mr. Minister, it's not too late. We can always add this on in a further amendment or adjustment to the draft as they are tabled today. So we should add that little part in and prescribe it. Now, finally, in relation to Section 15 of the amendment, which relates to Section 72 of direct grants, I adopt the comments made by the good member for Abao, Sir Honorable Fukatemu, as to his concerns. Now, this provision basically expands the scope of the powers of the minister to make direct grants. The original provision is about prescribes only 4 scenarios. And those scenarios are now being expanded into 4 more additionals. And those 4 more additionals are these. There is a proposed subsection A, B, and C. I will not labor. But E onwards are of some concern. That is this. Under Section 102, it relates to special agriculture business leases. So by this legislation, this amendment, the minister will be empowered to make direct grants in relation to any proposed special agriculture business leases. The concern is this. Not too long ago, in the recent past history, within 4, 5, 6 years ago, a special agriculture business lease commission of inquiry was conducted. And that commission of inquiry returned some reports. in those reports, there are recommendations for certain titles to be surrendered and cancelled. We are yet to hear whether that particular report's recommendations have been implemented. We do great justice to the country and the resources of the country that have been expended quite liberally on the inquiries that have been held. This one should be brought forward so that we know, the people of Papua New Guinea must know whether these SABLs have been cancelled as recommended by the inquiry and whether they've been reverted and cancelled and land to be returned to the people. A lot of fraudulent or quick fix titles were issued as a result, as found by the inquiry that I referred to. So that in itself is already controversial. I don't comment on section 130 and 131 because there's an assumption that the applicants applying for subdivision or consolidation are owners of the various titles and simply want subdivision. So it's common sense and logical that it should be allowed. And the minister should exercise that power expeditiously in favor of the developers that are coming through. So I take note and thank you for that. Section 100 is also of no debate, and that's in relation to special purposes leases to a public body. So if a public body wants to do a development or have access and based on public interest, this is the ordinary mode of obtaining a title. Section 65(2), however, is a bit of a concern, Mr. Speaker. Section 65(2) of the Land Act actually is in relation to grants of state leases under this Act. That is a general catch provision. What that means is the minister, into the future, will have the power to grant any titles direct, as long as it relates to a state lease under this Act. That's basically everything. Every title that has been land that has been alienated and subject of a state lease is now within the power of the minister to decide and make a direct grant without going to the board. The board is placed there for a particular purpose, and that is to provide a screening process and apply its own criteria, distribute assets or property in this country equitably and fairly as contemplated by the Constitution. And the National Goals and Directive Principles, there's a specific prescription of fairness of distribution of wealth of the nation. Land is a very important component of the wealth of this nation. On it, in it, and within it lies everything that concerns the balance sheet of this country and the private sector as a whole. To grant this power into one man or one person will go against the ambits of the prescription of or creation of the Land Board. And so this may create a dangerous trajectory for the country's wealth and land administration going into the future. But having said that, I want to also commend at a higher level the intent of the introduction of electronic data in relation to the records of the land's administration in this country, the GIS and so on. But with these additional comments I make, Mr. Speaker, I will support the amendments to the extent that I've made my additional comments and the recommendations and suggestions for the good minister to take on board. And I can only pray and hope that we can see some more additional insertions in relation to those prescriptions. Thank you kindly.